dear participants, we have reached the 35th edition of the Global Digital Encounters. This is, of course, an exceptional moment. And for this exceptional moment, the organizing team, Professor De Santes, Professor Javier Fernandez-Laschetti, Ribas Jimenez and myself have decided to dedicate the 35th Global Digital Encounter to the future of copyright offices, AI and digital environments. For this very important date in our Global Digital Encounters that exist now for more than 4 years, we also invited exceptional speakers. We have with us connected Mrs. Dr. Polo, who is the registrar, the acting registrar of the Hellenic Republic. She not only is of Greek, but Mrs. Papadopoulou is also a thinker in the IP family, in the copyright family. Numerous publications. The Greek office is known worldwide for its super dynamism within the European Union and beyond. And that's why we are so proud. We are proud as well to have with us Camila Santamaria, who was the registrar of Colombia, the copyright register of Colombia, one of the largest, one of the most active Latin American countries in the field of copyright during her mandate, and she is also known to be a thinker in the field of copyright. So that's why we wanted to have Mrs. Papadopoulou and Mrs. Santamaria with us today. One small issue relates to the third speaker, Professor Valérie BENABOU from France, who has a small technical issue. We saw her in our preparatory meeting, and she will join us hopefully very soon to the Global Digital Encounter. This encounter is dedicated to understanding how the IP system, the old copyright system constructed as of the Berne Convention in all our countries, can be adapted. What is the elasticity of the system in front of artificial intelligence and the fast development of digital environments? How does it affect copyright offices? What future will they have? How their role will develop? This is, of course, a very complex issue that relates to copyright, but also to other fields of intellectual property, and far beyond intellectual property, to many other fields of the economy. Yet we are the Global Digital Encounters for Intellectual Property, and today we decided to dedicate the first digital encounter that relates to the future of IP offices to the copyright offices. Why? Because this is something that is much connected to creativity, to freedom of expression, and to many other fields. So that's why we are so happy and so honored to have with us Daphne, Dr. Papadopoulou, and at the same time, Dr. Santamaria, to be with us, Camila, to be with us to discuss the future copyright offices. We are, of course, in academic freedom. We warmly thank all those who support the Global Digital Encounters throughout the world. We have a series of supporters for this pro bono activity, and we are so happy that we, as a Global Digital Encounters family, count on them as well as on our public. I would propose that we start, and I know that Laschetti, who is coordinator of the Global Digital Encounters next to Professor De Santes and myself, want to say a word of welcome to all of you. Also, one key expert and key academic in copyright. So, Professor Javier Fernandez-Laschetti, the floor is yours.
Welcome, everyone. And this is a special day in Spain. It's our patron saint, Saint Jacques or Santiago. And it's a holiday in part of Spain, but how can I miss the Global Digital Encounter? Instead of being in a swimming pool, I would be better here to hear the voices of experts in this very special and very interesting topic, because I think that from a long time ago, the role of the copyright officers was known, but related to something that was, let's say, classical. And suddenly, the appearance of digital world and the AI has put them in the forefront in this area. So it's very good to have people that know about this topic, and the topic itself is very interesting. So thank you very much for being here with us, and I would like to bore you more time. So Laurent, the floor is yours. Let's start with the digital encounter.
Thank you, Javier. And it is really great that we can dedicate this global digital encounter to copyright officers. And in part, as I've mentioned already previously, AI is profoundly changing the substance, the methods, the role of copyright, but also the functioning of copyright offices. Which is the future? What kind of future for copyright offices in the AI environment? This is a question that I would wish to ask first to our esteemed colleague Daphne, who is currently in charge of an office. She's actually among the speakers, acting registrar. So Daphne, of course, the honor is yours to start.
Thank you. Thank you very much.
Present what on this. Yes.
Okay, thank you. Thank you very much for the invitation, and thank you for choosing the subject, because I think the people in the copyright world, we almost, fed up with copyright and AI. Although it's very exciting and there are many issues, but there are, some overwhelming. So thank you that you put in under the spotlight the copyright offices. And to tell you the truth, I think it's not exactly changing the role of copyright offices. I think AI expands the role of the copyright offices, because it's actually we have many competencies, not only probably the Greek Copyright Office, the Hellenic Copyright Organization, but all the copyright authorities have many competencies, and now they're having AI to have to deal with the AI challenges and to have to see how we're going to deal with all this. And I think one possible role for the copyright authorities is to support, that we're doing already, support the right holders and the GenAI companies in limiting access or even licensing copyright of protected content as training material. And this is actually, the copyright authorities very often work like a central point of information. So the copyright authorities could work as a central information of resource of existing licensing solutions, or even technical solutions to limit access to content. And of course, when we say limiting access to content, immediately we go our thoughts to opt out to one Article 4. Paragraph 3 of the text of the DSM directive, which nobody actually was taking attention of this contention of this provision during the negotiation of the directive, but now really it's one of the main issues of the AI. So if we have to be sure, but even now we're not sure how this opt-out is going to work out. We're not so sure how it will be executed with appropriate manner. So the right holders, they are a little bit confused how they are going to exercise the opt-out, and so they don't let their content to be used during the text data mining procedure, and that means also to the machine learning. And so we want to act like a central point to collect and centralize all the information, but still we're not so sure if this we're going to propose, they're going to be really effective. So for me, it will be really good to have someone who have to free available protocols and standards for opting out, and the functionality of which then going to be tested and, let's say, authorized or accredited by European Commission, by the Observatory of the EU IPO, by the new established AI office. So we will have this list of ways that you could really, in appropriate way, exercise your opt-out, and so the right holders to feel legally secured that they did it in a proper way. So this is like to be the copyright authority to be really in a very, let's say, an informative role for AI. And let's say, just to continue, what else could be also the role of the Copyright Office could be to inform users, right holders, and the GenAI companies on the risks that are associated with the GenAI to infringe copyright, and what good practices in order to address such risks. And we can do this with because we have many ways to communicate with all the interest party. We have the frequently asked questions, so we have AI issues within. We have seminars in order to for the judges, so to expand the knowledge on AI and to understand how the new system will work, in order also to better implement the new issues.
Thank you very much. Thank you so much, Daphne, for this very clear vision that you have for the future of the Copyright Office under the AI environment. I know, Camila, that you made a lot to modernize the Copyright Office of Colombia when you were the director of the state office. So, what are your views on this question? What should be the future? What happened in Colombia, or what did not happen? Because we are still at the wake of the in the wake of the AI revolution. And how do you see that the Copyright Office should move? Do you agree with the approach, with the roadmap drafted by Daphne?
Okay, well, to begin with, let's start from the base that in Colombia, we currently don't have legislation regarding artificial intelligence. There have been, however, some roundtables with congressmen, with academics, with ministers, all of this in the pursuit of putting together a bill that could eventually become a law in Congress. So having said that, I can just make a preliminary forecast of a possible issue, challenge, or discussion that we might have in Colombia with precisely the opt-out provision that Daphne just mentioned. And this is because the Colombian copyright law strictly follows the principle of indubio pro auctore. And as we know, this principle literally translates into, when in doubt, everything will be construed in favor of the author. So, for example, in the specific Colombian case, the law says that any stipulation where the author transfers in a general or in an indeterminable way any future production or restrains itself from producing is absolutely void. It's also important to note that this concern that I have also extrapolates to the Andean community countries, which are namely Peru, Ecuador, and Bolivia, and of course, Colombia. And this is because we all share Andean Decision 351 of 1993 of copyright and related rights. And precisely Article 31 is, again, for me, practically the epitome of what is the antonym of the opt-out mechanism. Because this article basically establishes that any assignment or license will be understood to be strictly limited to the forms of exploitation expressly agreed in the contract. So for me, I do not see very feasible, or at least I don't see that simple, incorporating an opt-out provision in Colombia or in any other Andean community country, at least with what we have right now.
Thank you very much. Thank you so much, Camila. Welcome, Valérie. We are so happy that you could join. I wanted to discuss with you one topic on which you have published and reflected a lot, which is the market failure and how the Copyright Office can play a role in this very context of market failure under the AI environment. what duties should there be, how this should develop, how the EU can move in this very sense also as well. Valérie, the floor is yours.
Just to mention that I have just a slight point of view on the opt-out mechanism that we have adopted in Europe, because I guess that in case of generative AI, where the outputs are similar to works and that can be exploitable, I think you might reflect on the compatibility of the TDM system as it has been written with this kind of generative AI. And I'm not quite sure that the opt-out system will comply with the three-step test. I guess that we may open a discussion about the frame of this exception, not really sure that it can fulfill the special case, especially the special case condition of the three-step test as an exception. But just, well, that was a point. It appears to me that one of the key function of a copyright office to foster innovation, because AI is certainly something that we should manage to merge the interest of copyright with the interest of the industry. And it certainly is the problem of the metadata. The problem of the metadata is very key for the development of artificial intelligence, because if you don't have proper metadata, you cannot process the information. And you cannot expect to have revenue from the use of the work if they are not properly referred to, if they are not properly knowledgeable. And the problem now is who has the burden, the price of doing this proper metadata. And there have been a lot of investment by collective management society so far to try to develop a good mechanism of standards of metadata for the works. But so far, it has not been so successful, and we have lost a lot of money and time. Most of the people that are using works, massive repertoires, are facing a huge difficulty to have knowledge about what is the work about, what are the authors, who are the author, where are the rights, what is the price for the use of the work, and so on. And those are information that sometimes the users themselves are developing. I think about the recommender system like Spotify or Netflix. They are developing their own metadata to process the works within their own system. So we have a problem of market failure here, which is who has to have the burden and the price of constructing this metadata architecture. And it is my belief that maybe copyright offices can be the place to define standards, international standards, and open standards of metadata, interoperable internationally, and to help the development of the market for the benefit of all, because it will be easier for the users to find information, and it will be easier for them also to eventually remunerate the authors while using their work. So that's my thinking about the very importance of this metadata architecture and the role of the potential role of the offices in this perspective.
Thank you very much. Thank you, Valérie-Laure, for this approach on how to construct a new agenda for the copyright offices. And this also brings the issue of the organization of the Copyright Office in Europe. There are 27 national copyright offices. We have an embryo of copyright office at UIPO, but this is a very small one. This is only for fun works. How will this develop? And perhaps I would wish to rebound on this and give the floor to Daphne in this case. I think you may wish to comment or add some views on this.
I think it's perfectly fits after what Valérie has said, because I wanted to comment a little bit how the Copyright Office can help in identifying the words, finding the right holders. And exactly, I completely agree that I think the magical word here, the magic word is metadata. You cannot do anything. I think the whole AI system cannot work without the metadata. And that's exactly, there is an initiative that has started from Finland a couple of years ago, but now I think really it's really on the spot. It's about the Copyright Infrastructure Task Force, and has one of its aims is exactly this, to find common ground, how to form standards about this, the copyright infrastructure and the metadata. And one of the first projects also is about the opting out project. And there has many member states also members of this copyright infrastructure, and Greece through the Hellenic Copyright Office, it's also a member of this initiative. So it's really starting working towards exactly what Valérie has said, because it's realized that you cannot go on without this. And of course, it's adding a little bit of perplexity, the fact that you don't have a registration. So if you had the registration, copyright registration, everything would be much easier. But since you are not allowed to have a mandatory copyright registration, we have to find legally ways in order, to overcome this barrier. And this would come with this cooperation through also with all the copyright offices, but having something at the EU level, maybe, coordinating the whole thing. And the second one, I forgot to mention that there is a very interesting German decision that it's expected by the end of September, exactly on this issue of opting out in an appropriate manner, because it has to do with machine readable. So it's really interesting. Will be by the end of September from District Court of Hamburg. It's going to judge whether it was an opt-out declaration made in a website for some photographs. I think it's also appropriate because it was not done by machine readable means. So it's really getting exciting because it's not only theoretical, but comes really in praxis to see what we are all talking about all this time.
Excellent. And this brings us, I think, exactly to our next question, which is how do you use already AI in the Copyright Office? Daphne, you already mentioned on how there are plans to expand the use of Copyright Office, but you will come back on this, I'm sure. Camila, we are eager to know whether at the Colombian Copyright Office you use already what was done. Do you know about similar initiatives in the under-unpacked countries? So then we would move back to Europe with Daphne, of course.
Okay, well, currently there is no use of artificial intelligence in the Colombian Copyright Office. And also, as far as I know, and according to what my former team told me, whom fortunately still works at the Colombian Copyright Office, there are no short-term plans to use artificial intelligence in the entity. In regards to the rest of the Andean countries, I haven't had information either in regards of any current use of artificial intelligence within their offices. So
basically you consider that this is for the time being a transatlantic or trans-Pacific debate.
Exactly, yeah.
Thank you so much, Camila. Daphne, you mentioned already several elements on the use of AI and studies to use further AI. Do you want to further comment on the role of the Greek office, on how EU IPO may evolve in this respect and support the national offices if its copyright mandate is expanded?
Yes, actually, the Hellenic Copyright Organization already uses AI. Okay, a very simple form of AI, but it is. I told you we had many competencies. One of the competencies that the Greek Copyright Office has is to support the committee for combating online copyright infringement. And within this framework, the Copyright Office introduced something like a platform, let's say, that when the right holders want to file an application for the committee, they can upload the IPs or domain names that they allege that they are infringe copyright. And through all the information that we have fed the system, this system can actually say whether it's indeed an IP address that is infringes copyright, or regarding if there is an overblock of copyright. And this is communicated to the all players of this system, how the system of this the copyright infringement online works. And we're planning also expanding them. So we already use it. It's made our life easier. Of course, always there is the human intervention whenever the system, it's like an alert, something it's not very good running. So someone has to have an eye on this to see that's really what's happening. So the human intervention is always there, but it's made our life easier. What's in the future? Actually, it's very interesting that there is in WIPO a global index of AI initiatives for IP offices. There is 80 records. There is only one for a copyright office, and this is for Canada. It has to do with copyright registration. So it's really more AI will be more useful for trademark and patent offices, but still for copyright offices, there are ways that can help. Apart from what I said already, there is also the possibility that's how to help through the collective management AI and say, okay, why for the copyright office this will be for any use? Because one of our jobs is also to supervise a collective management organization. So when AI is used to the collective management, will make all the thing more transparent, more easier to supervise, and so will make actually the life of the copyright offices easier, let's say. And of course, there's also the possibility to use AI for a help desk in order to have not only SMEs, in order to have some first role questions and how IP could be of the use in concrete scenario. So let's say just very spontaneous. This is how I see what can be done also. And regarding EU IPO, I think the Observatory of EU IPO is doing many things in copyright matters. It's very much involved, and I think that we will be in the near future even more involved because all this, the copyright evolution that's happening in EU. But I'm not so sure that we have an EU copyright office. But I'm sure that all the competences of the EU IPO regarding copyright of the observatory will be even more expanded.
Thank you very much. Thank you very much for this comment. Indeed, the question on the role of EU IPO is already a bit too early to think about, but still, as you've mentioned, there will be a trend of expansion in this respect. It is also right that for many stakeholders, the big issue in Europe is not much problems with the copyright offices, but is the disorder with the copyright management organizations. So an issue that is a national one that has reached a European level that slows us down probably compared to the US. There is no single doubt that AI, to my opinion, as you have pointed out, AI may play a role to streamline the transparency of copyright management organizations and therefore to streamline a stronghold of copyright offices for a better supervision of copyright management organizations. Mm-hmm. I think that in my academic freedom, I can say that. And I think that it would be great that the EU legislators also support in a way or another this trend. And this brings us to the role that copyright offices may have to affect the legislative evolution of AI, its implementation and relevant policies. How can and even should the regulatory role of copyright offices develop and expand? How do you see that this can develop in a useful way? I would ask this question to the two of you who are or have been heading copyright offices. Daphne first. Which agenda would you give to copyright offices in this respect?
Listen, this is, I think, the most important, because the copyright office from Greece, as all the copyright offices or IP offices from all the member states, are participating in the working groups on copyright in the Council of Europe. So it's part of the legislative procedure. So there you have a say. There you can affect, more or less anyway, okay? But you can have a say in order how the things are going to be developed and evolve. But it's, for me, very important, and I'm really working towards this direction, not to be the decision of a copyright office how the relation between AI and copyright and how this, the relation will develop. I think there has to be a national strategy, a national policy. And that means that you have to have committees or some groups, small groups, that they have to be deciding these issues in order then to the copyright organization, the copyright office, in order to be able to implement this policy. So, because otherwise it will be, the opinion of me, myself, and I going to the European bodies and say, representing Greece. It has to be really a little bit organized and in government and level and a national level to have a strategy, and of course to have all the necessary dialogues with relevant stakeholders in order to see which is the best direction to follow and to carry for this.
Thank you very much, Daphne. Camila, do you want to comment also on this based on your experience, on your past experience?
Yeah, sure, Laurent. Well, in Colombia, the Copyright Office, to start with, it doesn't have the faculty to create laws. All Colombian laws are actually made in Congress and sometimes by the president, but under certain circumstances. The Colombian Copyright Office is essentially the entity that is legally called to implement laws and policies regarding all that is within its scope, that, as we know, is copyright and related rights. So this, therefore, could eventually include artificial intelligence, but only in what would encompass copyright and related rights. I would like to make a brief parenthesis, but that it's clearly related to the question, and it's that I would like to highlight a one-of-its-kind faculty that the Colombian Copyright Office has, and it is that it has its own specialized court within the entity. I know that copyright offices in the United States and, for example, also in Peru have similar faculties, but probably there are other countries where also they have this faculty or similar. But in our particular case, our jurisdictional office is 100% judicial, and it is not administrative in any way. So here it's literally a judge that we have within our offices whom specifically deals with copyright and related right matters, and not even the general director of the Colombian Copyright Office has any influence or incidence over the decisions taken by the judge. So in conclusion, although the Colombian Copyright Office does not have the faculty to create laws, it does have the faculty to create jurisprudence, which could eventually impact artificial intelligence, but insofar as it is linked with copyright and related rights.
Thank you very much. Thank you very much, Camila. I would wish to move to another question, which is relating to the toll for exploiting generative intelligence outputs. And therefore, there are options for a public domain, a paying public domain approach. This is an issue that worries very much in society, that worries business, that the fact that it is a paying one that may worry also consumers. Valérie-Laure, what are your views on this? How do you think that this toll on exploiting generative AI in outputs may evolve?
First of all, we have a problem of identification of what is copyrightable and what is not copyrightable. If we consider that according to the regulation on AI, there is now an obligation to mention if something has been made with AI tools, then you have an information on that. My belief is that if similarly work which is generated by artificial intelligence has not mentioned the name of an author, like a person, a physical person, a human person as a person is not mentioned in the attribution of the work, then you can presume that it's only an AI generated work, or it's mostly an AI generated work, and consequently you can consider it's in the public domain because it's not copyrightable. The problem is that when you say such a thing, you put something on the market which is less costly than a work, than exploiting the work. So you create a kind of unfair competition between copyrighted work where you have to pay the fee royalties and something which is completely freely available, though not exclusive, but freely available. So it would be, to my view, interesting to build upon the idea, the old idea of a public domain payant that was formerly, and I think in Argentina, they had this experience for a while. In Italy also, they had an experience of a public domain, payable public domain. And you can eventually consider that those outputs, which would be listed by copyright offices, would be exploitable under a kind of fee or toll, and that price for the exploitation of such output would somehow counterbalance the fact that there is no copyright on this, and and counterbalance the unfair competition. I think this is an idea which is there's a lot of complexity to enforce such an idea, but we can build upon that idea that first, those outputs are not in the realm of copyright protection, therefore they are in the public domain, and there's no exclusive rights built upon on it. So if you use such works, that such outputs, you bear the risk to have competition and someone else using the same thing without prior authorization but also that if you use those work and you have not contributed anyhow to funding the culture and the human being building creative works, then you pay something in counterpart, and this fees could maybe go to global funding on enhancing cultural diversity, creation for human beings. That would be the idea. I know it's complex, but I think it would be interesting to build upon that idea.
So thank you very much, Valérie-Laure. I think that what is very important for public is precisely to understand that what we are doing today is to get a review of the evolutions that have taken place and are taking place in copyright offices. But we also want to introduce on options that may exist. And this is why we are grateful to you, Valérie-Laure, for these comments. I have another question that is thrilling in this respect, and that is connected to the possibility of a repository for public domain works and items with original reason at national level. I think Valérie and then possibly Daphne, I would love to have your views on this. This is an issue that worries very much civil society organizations, consumers. What should be done on this to protect public domain works? Valérie, the floor is yours.
Yes, once again, we are lacking information on the status of works. Can we do something with them freely? Do we have to have prior authorization? Do we have to pay something for use? To whom, and so on? And when a work is not longer protected, it's quite difficult to appraise according to which rules, because even if in the European Union we have had harmonized duration, we'll still see a lot of differences and discrepancies between the different regimes, because we have not qualified what is a collective work or a collaborative work, and who is the author. We still are lacking the attribution phase of who is the author of what. So it's very complicated, still very complicated to calculate it, the duration of a work, and to know precisely when it is in the public domain, and then you can use it for free. And I think that it would be interesting to develop at the European level at least a calculation of a possible, even with AI models, I don't know, a calculation of duration in order to give the information, the proper information to the users that this work is in the public domain. And you can, even if you, there would be also a paying public domain for generative AI output. You could have information of whether you have to pay something to use or not, because it's completely free, depending on the duration or the type of entity who has generated the work, the input, the output. So this would be a role, I think, very interesting, because here again, it's very, there have been a lot of attempts to develop such tools at the national level, a calculation of the public domain. I remember some initiative in France 10 years ago where there was a calculator online, but the people found it so difficult that they let down this, because it was not precise enough, and it was not given a proper information at the European scale. And I think we need such a tool, and copyright offices or EU IPO may be a place to trigger such tool.
Thank you very much, Valérie-Laure. Daphne, do you want to add something on this?
Very
you want to comment?
shortly, yeah, very short. Just to also support this kind of idea. I think it would be very useful. I just agree to have this kind of repository for public domain works. And it's also, it will be useful because one of the main concerns is exactly how much has to be paid in order for the GenAI companies in order to produce machine learning. So it will give also the small and medium, or let's say smaller GenAI companies, the possibility to use freely content that it's the content is public domain. I'm a little bit skeptical whether such a repository. I think that this should be at the EU level, so it should be something that the EU IPO, of course, with the cooperation of copyright offices, should handle. But let's say it was not very successful, the previous database that it has with the orphan works, and I'm a little bit skeptical that it's something very, very useful, but in practice, sometimes this kind of works, they're not succeeding. But it will be extremely useful for various reasons, and of course to avoid also abuse, in order to not to have to pay for something that's not under copyright anymore.
Thank you very much, Daphne, for these comments. And this brings us, we are close to the end of our Global Digital Encounter. And this brings me to some reflections while listening at the three of you. Fundamentally, I gather that we need more duties for the copyright offices, that artificial intelligence is certainly not to replace the function of the copyright office, but on the contrary, means that its powers, its supervisory powers and its guidance powers may be increased. So maybe increased to strike a balance, a fair balance in society between haves and have-not, and between right holders and the public. And also in identifying works, let's say authorship on works that are in the public domain, orphan works, and so on. Certainly the progress of artificial intelligence may also bring some positive aspects in this respect. Daphne, you mentioned very rightly the question marks we all have on the repository of orphan works. This is a marvelous project. This is still an incomplete project. Technology, the growth of computing facilities, and therefore the development of algorithms, may perhaps mean that in 2 years' time, in 3 years' time, this project will be a success. This is a bit like automatic translation 5 years ago compared to nowadays. So personally, I share a form of optimism that goes also in the sense of what Valérie-Laure has mentioned on new projects that we need to carry forward. They are complex, but they are also sources of optimism for making the copyright system better organized. The role of the copyright offices should, in a way, expand as guidance and supervision. But AI is, from my personal view, may precisely support a better copyright world rather than the contrary. We have often said that the photocopying machine, that the internet have so much shaken copyright. Perhaps AI is a way to reorganize copyright. That would be a question that I may have to the three of you. Camila, do you want to comment on this? Or Daphne, or Valérie-Laure? Do you think that AI is an opportunity for a better copyright world?
I don't know. I don't know if you like me to just to jump in and give a first thought.
Exactly.
For me,
Yes,
it's
exactly.
actually copyright has every almost 20 years, I would say, but every some decades, and now a little bit more often, copyright has to face technological challenges. And always when there is a technological eruption, the copyright is shaking. But most of the time it's feasible to face these challenges. Sometimes some new rights have to be adopted in the past, or some new exceptions. So there is adaptability. But for me, the most important is that we don't and we shouldn't always reinvent the wheel. For me, the most important is to have the copyright basic principles and to try to implement this in the new notions. And even if it's this doesn't work, then we should go to the phase to say, okay, now we have to change something, because I think this is always happening with when something new, technological new, and there is a technological evolution, something happening. But we have to find, I think the solution has to be found within the basic copyright norms to adjust it to the new needs. And only if this is not possible, then to move to somewhere new. I'm sorry, this is my first thought about this.
Yeah, I totally agree with Daphne. I think that the copyright system has proven to be very resilient. And we have seen that, for example, with internet, that we were able to adapt and obtain protection of the works via even the ones that are on internet. So I think that it's just a matter of time, and we have to wait and see, especially in legislations like of world powers, to see in countries like mine afterwards how that system works. And with that, I think that it will be a positive outcome, and we will be able to work hand in hand with artificial intelligence.
Thank
Yeah.
you very much, Valérie-Laure.
I certainly agree with what has been just said. I think that the current revolution of what we call AI, but formerly we could say big data, is that so far we have thought the rules of copyright in the perspective of one work and one user, or several users for one work, and all the rules of copyright are thought within this frame of individual use. Whether we are now facing a mass of items all together with protected work, not protected work, never to be protected work, items that are processed by machines. And what is the need of the market is to have knowledge, to have information of this on the status of those data. Are they personal data? Are they protected work? Are they not protected work? And blah, blah, blah. So in this perspective, AI could help us to label the different status of the data, and to give information on the user, how they have to process and what are the duties in the perspective of the legal status of this data. And I think AI, because it's a way to process information very rapidly and at a massive scale, can help us to achieve that and to give proper information to better allocate the revenues or the status of yes or no use for the users. That's something we can achieve through the tools of artificial intelligence. But I think also that we definitely have to rethink the rules of copyright in this perspective of massive use of information, and not only individual use of an individual work, because it's not what it is about for AI.
Thank you very much. Thank you very much for these comments, Valérie-Laure. I think that this is an issue. We are at crossroads. We had, as Daphne and Camila has mentioned, every 20 years there is another technical revolution that is shaking copyright. Many of these revolutions have diluted or have created dangers for copyright. Perhaps AI presents more opportunities than dangers, except the massification issue, which of course is very challenging. AI offers fantastic opportunities as well for a safer, more stable management of copyright than what has happened over the last 2 centuries since we started to regulate copyright management. So there is a very positive evolution in this respect. And I think we are getting very, very close to the end of our global digital encounter. If you had one word to say, one sentence to say, what would you wish to mention to our public now on basically rethinking the Copyright Office in front of AI and of global digital networks, basically of global environments, global digital environments? So, Daphne?
Well, okay. I would say stay tuned that their changes are coming. Yeah.
Stay tuned. Oh, Camila?
Yeah, I think on my side, I think it's important that we all should remember, as within the copyright offices and even us as attorneys of copyrights, that artificial intelligence is not the enemy. Artificial intelligence is going to be a tool that will eventually, we don't know right now, but as Daphne says, we have to stay tuned. And I think that at the end, it's going to be a very positive outcome of working side by side with artificial intelligence.
Thank you. Valérie?
Yeah, just thinking that Copyright Office's role is providing information, quality information, quality metadata, informing the user on the status of work and use, and this is prominent in the future of AI. But it's starting raining cats and dogs above me.
It seems to be very idyllic.
So if I may synthesize,
it's written.
If I may synthesize the three of you, stay tuned, enthusiastic, and synthesizing, and Copyright Office is synthesizing the progress, the technological progress. So I think that this is a very beautiful message that we can give us now. Tuned in, enthusiastic, synthesizing. This is perhaps the outcome of our 35th Global Digital Encounter. I really warmly thank the three of you for your splendid contribution to the future of copyright, to the future of copyright in general. And I would leave the floor to our co-director, Manuel de Santos, for concluding this global digital. Thank you for your attention. Manolo, the floor is yours. Manuel de Santos, the floor is yours.
Thank you very much, Laurent, and thank you, Camila, thank you, Daphne, and thank you, Valérie. It has been extremely exciting listening you during this last hour. Yeah, you know, perhaps you don't listen me very properly, but I'm now at the northern part of Denmark, in the septentrional Jutlandia, in this very mythic place called Grenen, where the Northern Sea and the Baltic Sea meets. Yeah, this is a very important part of Europe. But I couldn't miss, as Javier said at the beginning, I couldn't miss at any rate listening you. You know, you can listen always the encounters afterwards and in fact, there are many, many hundreds of followers that later on will listen very carefully what you have said. But just listening in real life, yes, and in real time, is much more exciting. And you cannot imagine now. Now you cannot realize how many topics and how many messages you have brought on the table just in 1 hour. Yeah? Starting all around, you have started with this is new opportunities. This is further services for citizens and for right holders, licenses encouragement, getting central points for information. It's just things which come to my memory again and again. Yeah, all the challenges the directive brings, how the generative AI works with the metadata, how the different national offices and also the EWIPO should deal in terms of expansion of their role, how to work with the help desks for the small and medium enterprises, how to combat online copyright infringements. And then you have come to a conclusion, which is also very interesting. And I'm not very sure, I'm a little bit more tough. In fact, this is an extremely important opportunity for copyright offices, for the copyright system as a whole. I'm not so sure that we are just dealing with another once every decade technological movement. And when the generative AI will be expanded and will come to a much more powerful tool, I have the feeling that perhaps we should come back to another encounter at this very time. And perhaps we would realize that this change is much more deep, let's say, than the changes we had before. Anyway, it's time to close. We have enjoyed very much your speeches and your work. Thank you very much, you three all. Now we will have the summary with the report and with the references, and we will offer these to all the interested people. But certainly this is an issue, Laurent and Javier and Alvaro, we have to continue in the future, because this is a very rolling issue, and certainly the how the national offices, and I even would say the European Union office, yeah. And if one day we have a registry, European Union registry, there's so many developments that will come in the future that it will merit to come back again to copyright and to copyright offices again and again and again. Thank you very much, you all. Now, please enjoy the month of August. If it is possible, go to Grenen in the Jutland Septentrional, and then I will invite you for a nice beer. Be happy, enjoy these days, and you will have the 36th Global Digital Encounter just in a couple of months, beginning on mid-September. We will let you know exactly when, and thank you all the attendants for your loyalty. Be happy. Bye-bye.